Welcome to Immigration Uncovered, the Docketwise video podcast. I'm James Pittman, co-founder of Docketwise. I hope you all had a wonderful Thanksgiving. I am back from sabbatical, and I want to take today as sort of an update of obviously the major thing on the mind of everybody involved in the immigration system is the fact that we're going to have a new administration coming in January as a result of the election, and there are going to be major changes in immigration, in the immigration system, and in immigration policy. And I'm just going to talk today about what some of those changes might be, short, medium, and project what might happen long term. And just to let the audience know that we're going to be a trusted source of information. We're going to be conveying the information to you, talking to lawyers who are involved in advancing their clients' interests and trying to cope with the changes because elections have consequences, and we're going to have different policies. So let's talk about what the potential immediate changes could be expected starting January 20th, 2025. The incoming Trump administration may take a number of executive actions immediately that could reshape portions of the policy, and these would probably be done on day one. There might be a raft of executive orders signed on day one, and that could include terminating certain discretionary programs like temporary protected status. I mean, if you watch media appearances from the last several months, it's not a secret that Mr. Trump, President Trump, or incoming President-elect Trump, is not a huge fan of TPS, and we could see TPS rescinded for Haitians and for others who have been granted TPS. Another thing would be the Biden administration's expansion of the parole in place, which happened over the summer, which made many thousands of people eligible for parole. That could be rescinded by executive action. Also, DACA, which is also not liked by the incoming administration, that is something which also we could see go away. So now there could be policies that the Trump administration used in its first term, uh, such as the Remain in Mexico policy. We could see that coming back. The Remain in Mexico policy, as I'm sure you remember, requires asylum seekers to wait outside the U.S. while their cases are processed. And that was something which was seen in his first term. And the Biden administration attempted to reverse it, but it was blocked by the courts from discarding it completely. And also, we could see the disabling of the CPB1 app, which has been used by people on the Mexican side of the border to schedule appointments at ports of entry so that they could have a credible fear interview. Um, that was intended to bring order to the process of people going to the border and requesting asylum, right? So they could make an appointment through the app, go to a POE, and in an orderly way on a specific date, make their claim of asylum. It has been indicated it's probably going to go away pretty soon after the president takes office. Now, we could see a reinstitution of the family separation policy. I mean, there was an interview on Fox the other day with Tom Homan, who's going to be the sort of the border czar or advisor to the president on immigration matters, talking about deporting families together. But it's not to say that they won't reinstate the family separation policy. I think that it's bad optics, very bad optics. But we have to see because that is something which was hugely unpopular, but did scare a lot of people, and it may very well come back if they feel that that's something that they could do to advance their goal of increasing removals, significantly increasing removals. Another thing that we could see is stricter enforcement in the interior of the country, including worksite raids. So this is something that ICE in past years did more of, and it's sort of my sense is it's become less over the years. But looking at employers used to be that they would look at employers who really had a pattern and practice of violation. People, companies that just were not checking to make sure that all their employees were authorized to be employed and who made a practice out of not complying with the law. Those people were targets for enforcement, and we could see a significant increase in workplace raids. And what typically happens in the workplace raid is that the employees get rounded up and put in detention or otherwise put into removal proceedings, maybe detained, maybe released on bond, but one way or the other. They end up in removal proceedings, and the employer is usually fined, or if it's particularly egregious, there could be, criminal charges laid, but typically it's, a civil matter. So that's what we can expect right away on January 20th and in the weeks and let's say within a few months following. Medium term, we could see and increased use of Section 287G. So Section 287G is a section of the immigration law which allows ICE to deputize state and local law enforcement to carry out certain immigration functions. And there's two ways that they currently do that. One is like the jail based program, and the other is the just the warrant based program. In the jail-based program, the deputized, local law enforcement officers, when they encounter someone that they, who is a non-citizen or they believe is a non-citizen, they can ask certain questions to ascertain the person's immigration status and, ask them for documents and so on. And if they, believe the person to be unlawfully present in the U.S., they would then contact ICE and inform ICE of that fact, and ICE would then generate, a charging document, or if they want to pursue it. So that's like the jail-based program, and then sometimes ICE doesn't ask the state and local law enforcement to actually ask immigration questions, or they may not train them on that part of it, but they may do the interrogation themselves, but allow local law enforcement to serve, paperwork, serve warrants that ICE itself draws up. So those are the two ways that that's currently done. It's possible that there could be other methods that could be created as well, but we should expect to see 287G used, and the state and local law enforcement used as a force multiplier being recruited into. And if that should be resisted by local officials, probably they'll come under some level of pressure from the federal government, whether that might be, threats to withhold federal funds from the Department of Homeland Security or the Justice Department that are given to usually the Justice Department that are given to state and local law enforcement. But we would expect to see federal pushback and attempts to, to force them to comply. Another thing is we could see attempts to revamp the immigration system toward a merit-based system. So this is something which was like the beginnings of it were attempted during the first Trump administration. This was with the RAISE Act that was first put into Congress during the Trump 1 administration. And the RAISE Act is a piece of federal legislation which wants to do several things. It wants to basically, let's say, have the number of green card cases. So the thrust of this law is to move toward a so-called merit-based immigration system, which would be based on points. So family unity would not be as strong of a policy objective under the RAISE Act. Right now, family unity is a very important objective of immigration law. We have a lot of provisions in the law and a lot of built-up policies that strive to realize the goal of unifying families. The RAISE Act would do away with some of the family-based categories. For example, parents of U.S. citizens. This is a category that, people like Stephen Miller, people like Tom Cotton, don't like. Their opinion is once people are, grown-ups and they're U.S. citizens, they don't need to bring their mother and father on a green card. Instead, what they propose to do is have a non-immigrant visa for parents of U.S. citizens that would be a renewable non-immigrant visa, and the sponsoring U.S. citizen would have to show that they had taken out health care coverage for their parents that they want to bring to the United States on the renewable non-immigrant visa. That's their proposal. Other categories that they would like to get rid of would be the adult sons and daughters of permanent residents and the siblings of U.S. citizens. So some of the family-based categories would go away, but overall, the RAISE Act, at least in the incarnation that was introduced into Congress last time, the goal was to essentially cut legal immigration by half, and then also impose a cap. We can expect refugee admissions to go way down. So in the RAISE Act, there's a provision that would impose a cap of 50,000 refugee admissions per year, which is far below what we currently have, and also end the diversity visa lottery. That's another feature of the current immigration system that the people who sponsor the RAISE Act and people like Stephen Miller don't like. What there would be instead would be a point-based system where there would be points allocated for things like the level of formal education, whether it's a high school bachelor's degree, STEM degree, professional degree, etc. For English language proficiency, that would be a source of points for evidence of an extraordinary achievement, whether it's achieving high renown in a particular field, a job offer from a U.S. employer, or evidence of a job offer with high salary. Someone gets an offer which has a salary offer attached that's significantly higher than the average in the field. That would be something that would be a basis for giving points. Creating a new enterprise, investment and active management of a new enterprise. So those would be some of the bases which would actually where the points would come from. So that's the shift that's proposed in the Raised Act. So far it hasn't come to a vote in the Senate, and we're going to see. But I would expect that we're going to see significant push during the second Trump administration to advance the Raised Act or a bill very much like it. Oh, another development that we should expect to see is the public charge issue coming back. So you'll recall from the first Trump administration that there was a new form introduced, which was the I-944 Declaration of Self-Sufficiency. And this was a very expansive reading of the public charge ground of inadmissibility, right? Section 212A of the Immigration and Nationality Act contains a clause which says that someone's inadmissible to the United States if they are likely to become a public charge, right? It's 212A4. That's applied in specific ways in certain types of cases, but what happened during the first Trump administration was that the government attempted to really expand the usage of the public charge ground of inadmissibility and ask extensive questions on forms like the I-129, on forms like the I-485, and other forms. Ask extensive questions about any receipt of public welfare benefits, or and just ask for lots of data personal economic data that they could use to make a determination as to whether the person would be inadmissible based on the public charge ground. There was also, as I mentioned, a new form introduced, I-944 Declaration of Self-Sufficiency, which was a very long form. Uh, it was very, let's say, cumbersome for applicants and for their attorneys to complete. Introduced a significant additional amount of work into applying for a green card, and that ultimately was blocked. This expansion of public charge, both using the I-944 Declaration of Self-Sufficiency and the specific addition of public charge related questions on many of the forms, these are things that were blocked by the federal courts during the first Trump administration. But we can expect to see continued push to use that, and possibly slightly different version or slightly different angle pursued to try to get it back into the courts, and maybe get it through so that it won't be blocked this time. But I would expect more movement on that. I would also expect more movement on state immigration initiatives like Texas Law SB 6, or the Arizona various state laws that have been introduced in Arizona. I would expect, more state and local activity around attempting to legislate some immigration enforcement. Well, we intend here at Immigration Uncovered to serve as, a trusted source of information, and we're going to be bringing on people who are involved in each of these issues as it unfolds, as things begin to change, as these new policies come into play. We'll continue to have episodes of our podcast where we bring on leading people who are deeply involved in dealing with these changes and protecting and advancing their clients' interests, so that you will be informed, and stay tuned because it's let's say it's an exciting time to be covering the immigration law space, and there's going to be no shortage of things to talk about for the next few years. So I look forward to seeing you again soon on our next episode of Immigration Uncovered.